Welcome to Dealmaking with Laura DiFrancesco, the ultimate podcast for entrepreneurs and professionals eager to master the art of acquiring businesses. I'm Laura DiFrancesco, a seasoned M&A attorney and founder of Dean Street Law and a few other businesses. Join me as I demystify the complex world of mergers and acquisitions with in-depth insights and practical advice. Each episode is packed full of expertise, featuring discussions on the critical aspects of the acquisition process, from identifying potential opportunities to negotiating deals and successfully closing transactions. Whether you're a first-time buyer or a veteran investor, this podcast equips you with the tools and knowledge needed to navigate the mergers and acquisitions landscape with confidence. Welcome back to the Dealmaking with Laura DiFrancesco podcast. I'm so excited. Today we're going to be diving into asset purchases versus stock purchases, determining which is the best structure and deal structure for your acquisition. This is a really important key consideration that you should be determining well before you're drafting the letter of intent, because it will really influence so many of the deal term as well as the transaction documents. So we're going to be talking about decision factors for the strategic, financial, and other considerations that will influence your decisions, talk about some case studies, and really dive deeper into what an asset purchase is versus a stock purchase. This is really intended to be able to inform you and support you in this discussion, but I will say we go well deeper into this in our course, Acquisition Insights. It has over 81 modules detailing all the different legal aspects about buying a business, and of course, if you work with us at Dean Street Law. So I'm really excited to talk first about what an asset purchase is, which is really where the buyer purchases certain specific assets and specified liabilities from the seller. And so you can typically have all or substantially all of the assets, but only specific liabilities. And those assets may still have excluded assets, such as personal items of the seller or assets that may not be continuing to be valid and valuable to the business as an ongoing concern. And then you also will have liabilities that are important to assume in the transaction as a whole. So those liabilities may include ones that are related to ongoing business relationships with clients, or important liabilities such as benefits to the employees. So you have to determine typically with your attorney what those are going to be later on after the letter of intent has been signed, once you're going into the due diligence phase. But this is an important distinction and determination where you want to make between an asset purchase versus a stock purchase before you enter into the letter of intent. Ideally, there may be some information that surfaces during the due diligence phase that you didn't know about, but I do recommend that you complete pre-LOI due diligence, which we're going to go over in another episode. So tune back for more for pre-LOI due diligence to be able to know a sufficient amount about the business to be able to make an informed decision of whether it should be an asset purchase or a stock purchase, and what material deal terms should be included in your letter of intent. So let's go into a stock purchase. A stock purchase is where instead of purchasing certain assets and liabilities of the business, you're purchasing the ownership interests in the business. And so with that, it's generally going to be 100% or a certain percentage of those ownership interests. And as such, you're buying the business as a whole and everything that it includes, including real estate, if it has it, or including all of the assets and all of the liabilities. Now, there are some pros and cons to both asset purchases and stock purchases that we're going to be going into in greater detail. But I do want to take a moment, because so many folks are not familiar with stock purchases and how you can utilize tools within your purchase agreement that your lawyer can support you with, that we support our clients with, to be able to mimic a lot of the benefits of an asset purchase in a stock purchase transaction. So great considerations for both. We're going to dive deeper into the pros and cons, but I do want to first start by going over the fact that with those determinations of asset purchase versus stock purchase, the majority of the time, a buyer will prefer an asset purchase due to all of the benefits that it has that we're going to go into greater detail. But there are going to be a number of reasons that will dictate why a stock purchase is necessary. And so typically it will be those reasons that will influence a decision to make a stock purchase the better option for a particular transaction or the only viable option for a particular transaction. So we're going to dive into those in greater detail. And it's important to know that when you select an asset purchase versus stock purchase, you may still have in your letter of intent the option to elect the other, so that if the due diligence finds that, for instance, an asset purchase is not feasible, you still have the option to change to a stock purchase. And that's been outlined in your letter of intent how that will be possible. And then the other thing is that your transaction documents and terms related to each will be slightly different. Particularly your transaction documents will be vastly different from an asset purchase to a stock purchase. And separately, there is a merger. That is another type of acquisition, but we're going to leave that for another conversation. So what are the implications for the buyer in terms of an asset purchase versus stock purchase? With respect to tax, it is generally more favorable for the buyer to pursue an asset purchase. And that's because generally of depreciation. And there's an overall relationship of the tax implications of the business. And generally, on the whole, something that will benefit the buyer will conversely negatively impact the seller and increase their tax liability. And a situation that will positively affect the seller will conversely negatively impact the buyer and increase their own tax liability. So tax is something that is a very important consideration. And so in a stock purchase, the buyer won't have as many options to depreciate the business, and there are different tax structures. It is super important to speak to an accountant so that they can model out what these differences are going to be, because it really depends on what the amount of goodwill is, what the amount of depreciable assets are, and how significant this difference is. So I do recommend always working with an accountant to discuss this in further detail. On the whole, an asset purchase structure will generally be better for the buyer and have less tax liability for the buyer. And overall, a stock purchase will generally have more tax liability for the buyer. And conversely, an asset purchase will have more tax liability for the seller and less tax liability for the buyer. And then a stock purchase will have more tax liability for this buyer and less tax liability for the seller. Now, there are options. In certain situations, you may make tax elections to treat a stock purchase to be taxed as an asset purchase. Now, you do have to make sure that those qualifications are met to be able to utilize those elections. It's not every situation and every seller that will agree to treat an asset purchase or treat a stock purchase rather as an asset purchase. Generally, you don't treat an asset purchase as a stock purchase for tax purposes, but you do have the option that if you qualify to be able to treat a stock purchase as an asset purchase. So that is one way to utilize the benefits of an asset purchase in a stock purchase. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com to schedule a complimentary consultation. The other consideration is going to be strategic considerations. And so this would be with respect to consents, third-party consents that need to be obtained to be able to complete the transaction. If there are a number or even a few third-party consents that need to be obtained to complete the transaction, but those consents would not be required if it were a stock purchase, then that's a great argument for the most part of pursuing a stock purchase, because you really don't want to have third parties influencing the success of your transaction. There's a lot of moving parts already between two parties. And so when you have more than two parties involved, then it can really drastically influence your likelihood of success and really slow down the deal, taking something that might have been a 2 to 3 month process to something that may be a 6 or year long plus process to get approved. So that can drastically influence the financial impact of that transaction if you involve third parties, hence making the stock purchase a viable and probably the recommended solution in that event. Others, and let's dive deeper into those before we dive into some of the others, but those are generally going to be with respect to licensed businesses and businesses that have something that's non-transferable, whether that's a contract. So you'll want to make sure in your pre-LOI due diligence that you're asking what licenses the business has and how those may be transferred. And then also how, what the contracts state, what their material contracts state, and what you plan to do with those contracts. Are they material contracts that need to be transferred? If they are material contracts that need to be transferred, such as client contracts, and they require consent of third parties. If there's an asset purchase but not a stock purchase, then you would be more likely to pursue a stock purchase in that respect. Now, when you're looking at the assignability provisions, if there is nothing in the contract about how it may be assigned, it generally may be assigned without consent. If the assignability provisions include that consent is required, then of course consent is required, and you have to be very cognizant of the particulars of how that's structured and stated, because it may include that consent is also required if there's a change in control, and that change in control would also require consent even in the event of a stock purchase. And then you have to figure out whether it's feasible to obtain that consent, how that consent may be obtained pre-closing, and how that will influence the transaction overall. If you get too deep into the nuances of this and you're having trouble, of course, you can reference Acquisition Insights, or you can also schedule a complimentary consultation with us, and we would be happy to discuss it in further detail. We do provide services for a flat fee, draft and negotiate rounds of revisions for a letter of intent. This is all part of the process that we go through when we're working on the letter of intent, is deal structure and making sure that you have the appropriate deal structure. A lot of licenses can be non-transferable, but you have to know whether that license is held by the company or whether it's held by an individual, and what the transfer restrictions are on that license. Most of them will be non-transferable, but in the event that it is transferable, you need to know the process, how challenging it is, what the timeline is for it. All of those are going to influence whether a stock purchase or an asset purchase will be viable. Another recent influence is the SBA guidelines. So they have recently provided SBA guidelines to state that rollover or retained equity is permissible. So in order to determine whether you can utilize that will depend on how the bank has interpreted the provisions with respect to that seller rollover or retained equity. So most banks, while the SBA guidelines state that acceptable rollover or retained equity, while the guidelines do not require a stock purchase, most banks are very conservative in their compliance requirements, and they are requiring that it be structured currently, as of today, June 5th, that it be structured currently as a stock purchase. This may change, especially if the SBA guidelines state that an asset purchase is permissible. So many folks that have been pursuing SBA funding and rollover or retained equity are doing that in a stock purchase. But if there are banks that you see are lending under those circumstances and allowing an asset purchase, please reach out to me and let me know. I would love to know. I haven't heard of any yet, but it is definitely possible under the guidelines. It's truly just a matter of the fact that the SBA promulgates guidelines, and then the banks have to enforce those guidelines, but also may add additional requirements in addition to that. And so banks are generally very conservative in their compliance because compliance risk is very high for them. So they're very conservative and want to make sure that they're compliant as much as possible. And that's the way that they're currently interpreting it. So stock purchases have been very popular recently for that reason particularly. There may also be other strategic reasons for stock purchases, whether it is planning integration or something else down the line. Of course, we talked about contracts and being able to have continuity of contracts. The other thing from a practical standpoint is what else needs to have continuity and what would be disrupted if all of those assets had to be transferred. And sometimes that's not as clear as you think. For instance, bank accounts. Most bank accounts can't be transferred. They have to be reopened in an asset purchase, but they are transferred in a stock purchase. And so if there's a lot of money coming in and out very quickly, and changing bank accounts would be very disruptive to the overall operations of a business, then a stock purchase might be a strategic consideration. Another reason that I've had a client pursue a stock purchase is because the business had such great credit. It had wonderful credit, and it was a very credit intensive business. So they had a lot of equipment loans and various consistently reoccurring and rolling over credit that they were being extended, whether that be from vendors or from lenders or from equipment providers or anything like that. So they needed that credit history of the seller, and that was something that was really important to continue. So that was a reason why they wanted to pursue a stock purchase. So let's talk a little bit about the implications for each of the buyer and the seller, depending on what you choose, whether you choose an asset purchase or a stock purchase. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including letters of intent, pre-LOI and post-LOI due diligence request lists, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. Let's start with the buyer. They are going to specifically be concerned with exposure. And there are a lot of ways that we can mitigate that exposure. So in an asset purchase, the buyer benefits because they have selected their specific assets and specific liabilities, and they don't accept certain liabilities and are going to generally be protected from things that happen pre-closing. Of course, we all know that anyone can sue us for anything at any time, but generally they have that protection from something that happens pre-closing. You still want to do a lot of things to make sure that you are maintaining that protection, making sure that you have good reps and warranties, good remedies in the transaction documents, good indemnification clauses, but overall there is a benefit to asset purchases in that regard. So if they have a stock purchase, then they will be more concerned with how to protect themselves from unknown liabilities. And there are a lot of different ways that we can do this. We can do this through a holdback escrow. We are going to have a whole podcast coming up on the differences between what a holdback escrow is and the differences between a holdback escrow and another potential remedy, which is set off and clawback provisions against the seller note. So those are different remedies that we as attorneys use to be able to support our clients in having that protection from downside risk in a stock purchase. Of course, it may be utilized in an asset purchase as well. Those are common terms that we negotiate in all of our transactions, but they're going to become especially important. And in a stock purchase, things like representations and warranties, as well as indemnifications, are going to be even more heavily negotiated. Due diligence is absolutely critical. You do need to do a significant amount of due diligence no matter what, whether it's an asset purchase or a stock purchase. You need to be confident that the business that you're buying is the business you think you're buying. But in addition to that, if it's a stock purchase, due diligence becomes even more critical because of that ability to be on the hook for pre-closing liabilities. Now, you still have your indemnification, your reps and warranties to protect you. You may also have a holdback escrow as a potential remedy so that you don't have to adjudicate an issue. You may also have clawback and set-off provisions as a potential remedy. But due diligence is the step to, you always want to prevent any issues as much as possible, and that's your best step at prevention. Well-drafted contracts, well-negotiated contracts are going to be your second preparation for protection in the event either that you're doing a stock purchase or asset purchase, but especially important in stock purchases. And your disclosure schedules are important in any transaction likewise, but especially important in stock purchases. Your disclosure schedules are where there are exceptions to representations and warranties, or schedules that you need to include of particular liabilities that are known or not known, or specific assets that are being transferred or anything like that. Those are going to be set forth on your disclosure schedules. It may also have additional details in further detail from the purchase agreement, such as your allocation of your purchase price for tax purposes or anything else like that. You especially need to make sure that those are gone through with a fine-tooth comb, that you have as much information as you need to be in there in the disclosure schedules. It's better for a seller to disclose as much as possible, because then the likelihood that they would be on the hook for it if it's disclosed is less, but it is going to be highly dependent on the terms that are set forth in the purchase agreement specifically. In addition to the implications for the asset purchase on a buyer, it's going to make sure when you have an asset purchase, the buyer needs to be extremely careful with the listing of assets and making sure that that's comprehensive, and then also how all of those assets are transferred. It's one of the biggest mistakes that I see is that buyers think that they just need a purchase agreement to be signed and that's it. If you have an asset purchase, each asset class has a different legal requirement for how that asset class is transferred. And from a practical standpoint, you don't want them all transferred in one document, because if someone asks questions about a contract and they want to see the transfer of a contract, you don't want to have to disclose to them the entire purchase agreement where it shows how much you're paying for the business, et cetera. It's a bad situation. So from a practical standpoint, you always have each asset class transferred via separate legal mechanisms and then also via separate legal documents. And we go into that in greater detail in one of our episodes that goes into the key transaction documents. From a stock purchase, in order to transfer that stock, you have to have a stock power that has any transaction needs to be authorized, but especially in the transfer of stock, you have to make sure you know exactly who every single seller is, and that every single seller has to legally transfer that stock. So there are different mechanisms logistically, as well as from a transactional document perspective, of how that is logistically executed in terms of an asset purchase versus a stock purchase. With a stock purchase, it may be able to be done more quickly because there is less documentation, but on the whole, we see about it being the same. If there was a really big transaction, we're talking about $50 million plus, $100 million plus, really complex structure of the business, a lot of different subsidiaries or different asset classes, that it becomes considerably more influential in terms of timeline, that a stock purchase will be a more quick transfer of the business than an asset purchase, because logistically transferring that many assets with those many subsidiaries and everything is going to be considerably more difficult. So that is one of the things that is going to deeply influence the transaction, particularly as you get into bigger transaction sizes. So we've talked about a lot of the influences on the buyer, but let's talk about the influences on the seller. We talked about the tax implications, but from a seller's perspective, what should they be thinking about? A seller needs to be very upfront and provide as much information as possible through the due diligence process, as well as especially going through and parsing through those representations and warranties and disclosure schedules, especially in a stock purchase, in any deal, but especially in a stock purchase. It's critical that those are very carefully addressed so that anything that is disclosed is going to generally cause less liability. And of course, the buyer in those situations in a stock purchase is going to be more likely to negotiate the points of indemnification and representations of warranties, hold back escrows, set off and clawback provisions against the seller note more considerably. And so as you see that, market terms tend to favor buyers a little bit more in those regards with respect to stock purchases. Then in addition, the stock purchase with respect to the seller, they need to make sure that all of their, and this is for the buyer and due diligence too, but they have to make sure that all of the organizational documents for the buyer, or for the seller rather, are in good shape. And so because all of the equity is being transferred, you also have to then go and look at all of the historical transfers of equity and have those all been properly completed, because if they have not, you could have a prior owner try to litigate or make a claim against the business because they don't believe that they were properly bought out or something earlier on. So in addition, let's go into some of those legal ramifications that we talked to and exposure for past liabilities. And with respect to exposure, we talked about how we can limit that exposure through representations and warranties, disclosure schedules, your holdback escrow, set off and clawback provisions to the seller note. So there is a lot of ways that we can address that. Ultimately, like I said, anybody can be sued at any time for any reason. It's important to remember that, especially if you're going to do an asset purchase and you're assuming the name of the business. The likelihood that you won't be brought into a suit is pretty small, so you will need to rely on all of those protections. While there is more risk absolutely in a stock purchase than an asset purchase, there's really a lot that we can do to address that. We also talked about the tax implications. So the tax implications, if you have an asset purchase, it's generally more favorable for the buyer. If you have a stock purchase, it's generally more favorable for the seller. But you can always request that a stock purchase be taxed as an asset purchase, and that is pretty common. So those have been a deeper dive into an asset purchase versus stock purchase. It's typically going to be driven by a few things, such as business continuity, the transferability of certain assets such as contracts or licenses, whether you're using the SBA financing to utilize change or rollover equity. Those are a few considerations, but I do want to note that this isn't exhaustive. These are the main considerations, but there may be some other things that may influence your decisions, other strategic considerations that may influence your decision. Ultimately, there are pros and cons to each. If either works, there's a lot that we can do to protect both parties in either situation. I hope this has been helpful. I hope that this has empowered you in your decision making so that you can make informed decisions, that you understand the importance of these complex choices. And of course, we're always here to support you both through Acquisition Insights, our online course. It also has all of our templates, including our LOI templates, our pre-LOI due diligence request list, post-LOI due diligence request list, material deal terms list, and so much more. And Dean Street Law, we provide custom legal services for buyers and sellers in the M&A lower middle market. We would be happy to support you in your acquisition or divestiture. Thank you so much for joining me for this episode. I hope you've enjoyed it. Please be sure to like it, rate it 5 stars, review it, share it with your friends, share it on social media, tag me at Laura DiFrancesco on LinkedIn or search funder LM DiFrancesco on Twitter. And I really appreciate you taking the time to spend with me and learning a little bit more about asset purchases and stock purchases. Happy deal making. Thank you for joining us on this episode of Deal Making with Laura DiFrancesco. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please make sure to follow and subscribe to Deal Making with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please make sure to leave a 5-star review and share the podcast with anyone who may benefit from it. Sharing our podcast is the best way to show your support and help us to continue making more content just like this. So please be sure to take a screenshot and tag us on social media whenever you can. For more in-depth resources, be sure to visit our website at deanstreetlaw.com, where you can find articles, guides, and more information on our services. Or you can also visit lauradifrancesco.co/the-shop for more information on our legal courses. Don't forget to follow us and connect with us on social media for the latest updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LM DiFrancesco on X, and at Dean Street Law on Instagram. Be sure to join us on our next episode where we'll be discussing more deal-making tips and insights. I'll see you there.